2.
Yes, my Lord, ground 3.
Thank you.
That's in the judgment below, paragraphs 68 to 72, and in my skeleton, paragraphs 69 to 81.
So which paragraphs?
So judgment below 68 to 72.
Yes.
And my skeleton 69 to 81.
Thank you.
And I'll start, if I may, with the law, my Lord. The law on apparent bias is well established.
Yes, it is.
There is a helpful summary of the principles in Bubbles and Wine, the judgment of Lord Justice Leggett, as he then was. It's in the authorities bundle, tab 19, pages 404 to 405. And I accept, my Lords, that the context of that case is obviously entirely different. Firstly, it is a judicial context.
Yes.
The facts being a conversation between counsel and the judge in chambers, and in any event, no appearance of bias was found in that case. So I'm not relying on the case for the facts, only for the statement of principles at paragraphs 17 to 19. And it is well established that it's a two-stage approach. Firstly, ascertain the relevant factual circumstances, and secondly, ask whether those circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility the decision-maker was biased. There's a helpful definition of bias just before the flattery reference. Bias means a prejudice against one party or its case for reasons unconnected with the legal or factual merits of the case. So that is, in my submission, what bias is meant to mean. Paragraph 18 then enunciates 3 further principles, all of which are very well established. Firstly, fair-minded observer is not unduly sensitive or suspicious, entirely accept that, nor is he or she complacent. Secondly, the facts and context are critical, with each case turning on an intent to focus on the essential facts of the case. And the third of those principles in my submission is not directly relevant here, given we are dealing with local authority decision-making. That relates to judicial decision-making. Then paragraph 19 rightly identifies that one should not confuse the fair-minded and informed observer with the person making the complaint, because they will inherently look at it through different lenses. My Lord, there's one other case I would like to look at, and that is the decision in Georgiou against Enfield, which is tab 4 of the authorities bundle. So this first instance decision of Mr. Justice Richards. Yes. And my Lord, we see from the head note that the case concerned applications for planning commission and listed buildings consent to change the use of a grade 2 listed building into offices. Some of the members of the planning committee that ultimately determined the application had been members of the conservation advisory group, which, although it hadn't voted, had essentially made statements of support for the application following previous meetings. And in this case, Mr. Justice Richards, as he then was, does find an appearance of bias. The passage that I rely in particular on is paragraph 31, which stems from the discussion starting at paragraph 29. And the proposition for which I cite this authority is that it is necessary when considering apparent bias to look beyond pecuniary and personal interests and consider, in addition, whether from the point of view of the fair-minded and informed observer there was a real possibility that the planning committee or some of its members were biased in the sense of approaching the decision with a closed mind and without impartial consideration of all relevant planning issues.
That's been the law since at least the mid-19th century.
Yes, my Lord. As I said, the law is well established and I have nothing to...
Yes. So if you have a pecuniary interest, then that's it.
That's it, but that's not this case. It's not my case. My lord, the key in my submission is the application of the facts.
Yes. Now, can you just help me with one thing? What's the role of this court? We're not the court of first instance.
No.
We are the court of appeal.
Yes.
We don't usually sit simply to retake the decision.
No, I quite accept
So
that.
what do you say is our function on this ground? The judge at first instance has got the principles,
Yes.
applied them to the, as you say, intense scrutiny of the facts is required. He did that. So what's our function now?
My submission is, on the facts as he found them, his conclusion was rationally insupportable.
Right.
And that he made an error of approach if he approached it in the way that he perhaps appears to have done, and I'll develop that.
Right.
In terms of the facts upon which I rely, the first...
Would it be helpful to look at the judgment first to show us the passages that you say are wrong?
Yes, my lord. So really, there's a single passage which we can look at,
Yes.
which deals with why I say he is wrong. So it's the judgment below, and paragraph 72 is in my submission where he reaches a rationally insupportable conclusion.
Right. And in a nutshell, it's rationally insupportable because...
In circumstances, I'm putting it at its simplest, where the chair of the council had refused to permit another member of the local authority to attend the meeting and speak on the grounds that they could only speak in support and not in opposition, the only rational conclusion is that there is an appearance of bias in my submission. That is the case put at its simplest.
Right.
That is reinforced by the other contextual facts found by the judge in my submission. In terms of error of approach,
Yes.
that in my submission arises from paragraph 72 read in the context of 69. Because in my submission the judge focused unduly on personal and pecuniary interests.
Well, you've got to start with 68. I mean, do you have any criticism of 68?
No.
Then he's dealing with predetermination and predisposition, which is a particular planning thing, or a local authority thing. Then he says the classic case is personal pecuniary interest. He says that's not suggested here. And then he says what's relied on is the run-up to the July meeting, the during. So what's wrong with that?
Well, what is wrong is, as I say, what happens in paragraph 72 in light of that, which is to say, as he does, whatever view is taken of this conduct, i.e. even if the claimant has made out all these points, it does not support a finding of apparent bias.
That's your first point. Where's the wrong approach?
Well, as I say, in my submission, an explanation for the rationally insupportable conclusion is perhaps in paragraph 69, namely an undue focus on personal and pecuniary interests and a failure...
But he says that's a classic case. He doesn't say that's the only case.
No, he doesn't, my lord.
So the approach was wrong because he focused solely on personal and pecuniary interest.
Well, I don't say he focused solely on it.
So what is the wrong approach then?
He doesn't seem, as I say, or he focused unduly on it would be my submission.
Right.
But my key point, and I recognise that in all probability to succeed on this ground I must make it good, is that the conclusion of paragraph 72 is rationally insupportable.
Yes.
So, Lord, in terms of the findings of fact, the first relates to the refusal to permit Councillor Churchman to speak unless she could support the grant of planning permission, and that's dealt with in the judgment at paragraph 16. And in my submission, it would appear that the judge accepts that what is accepts that that is what happened. The evidence underlying that finding, and I don't know whether it helps together or I can simply give the references,
Yes.
includes the email of the 25th of August 2021. So that's in the supplementary bundle, tab 25, page 265. So, my lords, what this is an email from Councillor Jarman to various people, including other councillors, Councillor Adams and Councillor Lilly, which attaches screenshots of an email from Councillor Churchman to him, and the text of the email from Councillor Churchman is in white on the black. There's also a witness statement from Councillor Churchman behind tab 4 on page 24.
Sorry, which tab?
Tab 4, page 24.
Yes.
And it's the fourth paragraph beginning in respect of application.
Right. The first approach, it seems that his answer was he refused me permission on the basis that the site is not in my ward.
Yes.
Do you have any complaint about that?
Well, not per se, although the council's constitution does say that people whose ward it is not may speak, and indeed generally will be allowed to speak, provided they are speaking about a material planning consideration not otherwise covered.
And which couldn't have been raised with the officers in writing beforehand.
Yes.
You do need to have the whole thing.
Presumably, certainly from what I read that screenshot in full. Presumably, what was in Councillor Brodie's mind was that this isn't in your ward, so there's a discretion to allow other councillors whose ward it is not to speak. I'd quite like to have a balance of opinion at the meeting. I've got plenty of people who want to speak against, and so I would prefer it if you don't speak, if you're also against it. Is that what it amounts to?
But, I mean, that isn't what he says in his witness statement,
Right.
paragraph 7.
Right. Will you show us that?
That's tab 8.
Right. So what does he say? In a nutshell, has he denied this ever happened?
He says, paragraphs 9 to 10.
Yes.
I indicated to me that she'd be speaking against the item and she failed to identify any material considerations were not already put to the committee. On that basis, I declined to invite her.
Well, why is that materially different from what I just summarised?
Because what my lord said is I wanted there to be balance, but there's no evidence about other people having approached him or whether it would result in balance.
Well, Councillor Churchman's screenshot appears to say that. But there were other councillors. Have I misunderstood that?
Well, I mean, I think...
It's on top of page 266. I cannot prove he said that, no witnesses, but he added that there were plenty of people to speak against it, and he didn't need me as well.
Yes, but it doesn't say that there weren't people to speak.
I see. Right. Anyway, so what you question, do you, what he says in paragraph 7 to 10 of his witness statement?
In paragraph 7 to 10, he doesn't directly address this point.
Which part?
What point?
The point that it is alleged that he said you can only speak if you support.
I see. In paragraph 10 he says, I apologise to Councillor Churchman. I did provide her with an opportunity to discuss with me what different grounds she was going to bring to the committee. To me, Mr. Streetman, I'm not sure what this is other than somebody possibly getting it wrong, but doing their best to manage a committee. But we're not here to second guess how councillors manage their committees. We are here to intervene if they meet the Porter and McGill test for apparent bias.
Yes, my lord. And so the context of that remark is in my submission everything.
Right.
And the context is the other factors upon which I rely. But I do say, as a bald proposition, what Councillor Brodie says in his witness statement is not, I was seeking to achieve balance. He doesn't directly address that. He doesn't suggest that was his state of mind.
Okay, forget about that, right? If that's introduced a red herring, let's just forget about that. Just on the basis of what he does say at paragraph 7 to 10.
Yes.
Do you dispute what he says?
Well, I say and it's the way the judge puts it, he doesn't deny that he said, you can only speak if you speak in support. And
Yes, but it's the context. It is the context, not because I only want supporters. I don't want anyone to speak against this project. What he says is, I've got lots speaking against the project. I don't want you to speak as well, i.e. if you're going to replicate what's being said. Isn't that a fairer balance?
Well, there's a difference between if you're going to replicate what's being said.
Okay, forget the red herrings.
Sorry.
It really doesn't help. I mean, I know my lord introduced one and I introduced one, but it's clear what we're saying to you, Mr. Streeton, and it's not going to help to inadvertently misrepresent it. This is not a case where he was saying, I'm not having people speak against this motion. It's a case where, according to her screenshot, he said, I've got lots of people speaking against it. What are you going to add?
But it is a case in which he said, you can speak in support. And that, in my submission, is very surprising.
To me, that's not surprising at all, if I may say so. That's why I introduced the concept of balance. Now, maybe I was wrong to do that, but I was trying to be helpful, that he just wanted to have a variety of views so that everyone could be as well informed as possible.
But in my submission, my lord, the best way for everyone to be as well informed as possible is, provided people are going to speak about material planning issues, to allow them to do so in accordance with the general rules.
You may be right. And maybe it was a bad thing, maybe it was a wrong decision, maybe if we'd been running the committee, we would have done it differently. But that doesn't mean that somebody's guilty of bias.
Well, it's an appearance of bias, rather.
No, I know. Forgive me, Mr. Streetman. You can take it.
We do the law.
We do know Porter and McGill, right? We do know what the test for apparent bias is. So every time, we're not going to repeat it verbatim. Okay, but can you, as my lord says, can you focus on what we're really asking you about? Now, is this any more than someone innocently, perhaps wrongly, I know you disagree or your clients disagree with what he did, I appreciate all of that, but why does it amount to the Porter and McGill test of bias?
Well, in my submission, viewed in context, it does.
Right.
And that, I don't think I can improve it by repeating it.
All right.
The context upon which I rely includes the evidence that Councillor Brodie sought to, as they, the other councillors themselves perceived it, manipulate them into not participating.
Did they participate?
Some did and some didn't.
And why did those who didn't participate?
Well, Councillor Adams didn't participate because he understood that it would create a risk of an appearance of predetermination he said he subsequently came to realise that there was a difference between predetermination and predisposition, and that he didn't feel he had been predetermined.
So where's the bias there?
Well, my lord, it is the cumulative effect of the factors taken together in my submission, but it is in my submission very unusual for a councillor to, whether they're chairing the committee or not, to go around and take it upon themselves to perform the role of the monitoring officer by discouraging others from attending on grounds of predetermination, whether or not you believe them to be predetermined, and certainly to approach them on multiple occasions and to make that point to them.
Was this a controversial application?
Yes, my lord.
Had people been going around saying things?
I suspect they have, my lord, yes.
That what happens often with all things when you want a shed or a garden trampoline? Maybe different circumstances, you see.
Yes, my lord, I completely accept that it is all contextual.
Right. So is there more evidence you want to show us?
Well, I mean, frankly, the points are made in my skeleton,
yes.
And I wouldn't do more than take you to the references that are set out in my skeleton.
Right.
So unless it's going to assist the court for me to go through that evidence.
I mean, your best point is Councillor Churchman, isn't it?
It is, yes.
Yes.
And that's why I put that front and centre.
And the rest is your context, or interpreting what happened in a way that shows that Councillor Brodie was out to stop this.
Yes,
voted down.
exactly right. It's how you interpret that viewed in that context, including everything from before the committee through to the litigation and the emails which we say there is evidence exists but were never disclosed, for example. But I mean, the point is made in my skeleton. I don't think I need to repeat it, provided the court has the point.
We do have the points, but I don't want to stop you. If there's anything you think is important that we should see, then we will look at it.
No, I don't. I think you understand what my submission is, and I don't think it will assist me to take you through it.
Thank you very much. Right.
So in light of that, I can deal with ground 4.
Yes.
The judgment below is paragraphs 63 to 65.
Yes.
And it's in my skeleton 82 to 90.
Thank you.
I can set out my positive case on this issue very briefly. The judge found at paragraph 65 that Councillor Brodie excluded Councillor Price and that was procedurally improper. Now, in my submission, for the reasons I was canvassing at the beginning, that impropriety infected the first resolution, which members were advised to and subsequently did take into account at the final meeting on the 25th of April 2023. And to make that good with reference to the judgment, paragraph 40 of the judgment refers to the advice as the last 3 lines. The advice given that would be a material consideration.
Yes.
So what will be material is that if Councillor Price had been there, he'd have voted against it.
Well, yes, my lord. If they were told, because my submission is this: members were told there was nothing wrong with what happened previously. If they had known that in fact what happened previously was procedurally improper, then they might have been more willing to revisit the merits previously. They could have either set that from their mind or at the very least taken into account the procedural impropriety. And as a result of that, they might have reached a different decision on the second occasion.
But isn't what happened, Councillor Price did attend the second time. They did have a motion to consider it afresh, and Councillor Price said, I would have voted for it. I voted against it last time, but the world has moved on, the farm is closed, and we need the housing now. So isn't that the true basis of what happened?
I don't think that is an entirely fair encapsulation of what happened, my lord. He does say those things, I'm not suggesting to the contrary, but he also says that essentially it would be falling into a trap to revisit the previous...
He doesn't want to revisit it, even though he would have voted against it.
Yes.
But they did revisit it.
Well, my lord has clearly read what he says on page 327 at 119.
Yes, I've marked 2 paragraphs. The outcome of the previous decision would have been different if I'd been on that committee. If I participated in a reconsideration of this whole application, but there'd be a weaker position now. A lot has changed. Certain ships have sadly sailed. Something else that's changed is the huge reduction in rental properties available. And he said that, and then they go on, and he did participate. He did vote, didn't he?
Yes, he did, but it's the paragraph before that I rely on, in which he said that it would be a mistake to reconsider the whole application, a big mistake, and walking into a trap. It's something that will damage our local planning authority. So his position was, I do not want whatever has happened to damage the perception of the propriety of this authority, and therefore we should put that behind us. I'm not going to revisit it.
Yeah, but they did revisit. They voted on it again.
Yes, but having regard to the previous resolution.
No, we're mixing up certain things here. He didn't want it reconsidered again. He wanted a line drawn under it. That didn't happen. They did revisit it and they had a vote. So that happened. Now, if it happens and they're voting, what's material is what is Councillor Price saying, and what he's saying is I would have voted against this. We made a mistake 3 years ago. It's too late now.
I think he's saying it's too late now rather than we made a mistake 3 years
Okay,
ago.
please don't worry about the details of my own elaborations. Where I come from, we get excited in Wales. But you know what I'm saying. He's saying, I don't want it reopened. It was reopened. He lost that argument. There was another argument, should it be granted or not, and that's his view about it.
My lord, I don't think he did lose that argument about I don't want it reopened. I think when he says reconsider the whole application, what he is saying is we should just move forward on the basis that there's already been a resolution and consider the curlew mitigation.
He lost that argument because there was another vote.
There had to be another vote because of the curlew mitigation.
No, there was another vote after the curlew litigation. They had the first vote about the curlews and they thought the curlews were going to be looked after.
Yes.
Then they discussed it a little bit more and a motion was put forward, I think by Councillor Andre, but I may be misremembering, and the chairman went round the meeting again, not from left to right, A first, but the other way this time. So if Councillor Price's position was there should not be a vote, we should rely on the resolution of whatever date it was in 2021. However I describe it, a second vote was taken for a second resolution. That's what's happened.
Yes, well, that has happened.
Right. And at that second vote, on that vote for the second resolution, he took part.
Yes, my lord.
And he said, I would have voted for it this time, or even though I was dead against it last time.
I think he says that before I vote.
Yes, I know. But they're not going to have forgotten it.
No, I know. I apologise, my lord. I don't mean to be difficult. I really don't.
So where's the material error?
In my submission, the material error is if the first decision was vitiated, to take it into account when you made the second decision. And it's not just about Councillor Price, it's about the committee as a decision-making body as a whole. And it is absolutely true, we can see it on the page 336, that Councillor Price voted in favour for the reasons that my Lord Justice Lewis has enunciated. That isn't my point. My point is, if the committee as a whole had been aware that the previous decision was legally erroneous, then it might have made a difference to their decision the second time around.
They'd have to vote on whether to approve it or not.
Yes, having regard to the fact that the previous decision was unlawful, which is not the basis upon which they approached it.
Unlawful because of procedural irregularities.
Yes, my lord, yes.
And then they'd have had to think, well, gosh, this was jolly unfair. Councillor Price wasn't there. He should have been. What's he say now? And he said, well, I just told you a minute ago, don't forget. Anyway, that's your submission. They should have been told there was a procedural irregularity. They would have said the world will stop, the planning commission must be refused. Or might have been.
They might have. And the point is this, whether or not Councillor Price himself was satisfied that they should put it behind them, other people might not have been.
But they didn't put it behind them, they voted.
Yeah, well, precisely. They didn't put it behind them, they voted. And they voted on the assumption that the previous resolution was lawful.
So is the problem that if a resolution is unlawful, it can never be revisited unless you do it squarely acknowledging that it was unlawful?
You either put it from your mind,
yeah,
and don't take what happened previously into account at all,
yes,
or you do it squarely acknowledging it was unlawful.
Yeah. So what you can't do is say, we're going to look at the merits of this planning application now, in the light of all the information that we now have, you just can't vote. You can't vote for it because there's been an unlawful resolution 2 years earlier.
Well, you can if you completely ignore the previous resolution. If you say we're not going to take that into account at all.
Right.
The other problem is you haven't got an unlawful resolution. You've got a resolution which is valid and lawful until quashed.
Yes.
So they aren't actually ignoring an unlawful resolution. They're ignoring a resolution which might be procedurally unlawful.
Yes, it's Schrodinger's resolution at that
Yeah.
point. But the point is that the judge found, paragraph 65 of his judgment, that it was unlawful and that I was in time to challenge on that basis. But he said it wouldn't have made any difference. And my submission is, well, if it was taken into account as a material consideration, then it was also material that it was on a basis which he, a judge of the High Court, had found to be unlawful.
Yes.
And that, I mean, that is the essence of my positive case on this ground.
And what was the reason he said that it become academic? Is that what he said?
He does say that it's become academic. It's paragraph 93 of the judgment.
Yeah, well, show us what you criticise about his judgment. Because again, our function is not to take this decision again,
No, my lord.
but to see why he was wrong.
Yes. So it's paragraph 93.
Yes.
And his approach is to say, about 4 lines down, the members were advised that the July 2021 resolution was a material consideration, but it was a matter for them individually as to the breadth and length of the debate, while some of those who had previously voted in favour of the application were content to confine their contribution to the issue of curlew habitat. It's clear that some of those who previously voted against the application debated its merits afresh, i.e. some people did it one way, some people did it the other.
Yeah.
The officer's report was presented in detail with a recommendation that the application should be granted. In my judgment, that was a proper process with which this court should not interfere. Now, in my submission, that in the context of his prior finding is an error of approach, because once he accepts that that previous resolution was unlawful and that it was taken into account, he is accepting the link between the unlawful resolution and the final decision, but says it's academic.
Yes.
And that is my submission.
That's wrong. Okay, so that's wrong. I understand that submission. He goes on at 94 to posit an alternative. And he recites section 31, subsection 2a.
Yes.
And what's he doing in paragraph 95?
So he does it, he finds on section 31 in relation to various points, but not in my submission on this aspect of ground 1.
Yeah, that's why I asked you. What is he saying on your submission? What is he holding at 95?
So he finds that the aspect of ground 1 which related to the length of the committee hearing, which he deals with in his judgment, and it's not a point that's been appealed. At paragraph 67.
Right.
So that's what he's referring to there.
Okay.
And for the benefit of my lords, that was an argument that it was unlawful to proceed with the meeting for more than 3 hours in circumstances where someone had objected, and the point taken by the respondent was there was no point of order, and the judge accepted that argument and said there was no point of order, and therefore it was a procedure by affirmation, and in those circumstances not unlawful despite someone having objected. So that's what he's referring to when he says that the timing aspect of ground 1. So he does not find on section 31 in relation to this aspect of ground 1.
This aspect being?
This aspect being this aspect being
In a nutshell? The participation
yes, my lord, the participation of Councillor Price.
Well, the non-participation.
The non-participation of Councillor Price,
yeah.
in relation to which he rules
Right.
paragraph 65.
Okay. So although it's framed as an alternative submission at the beginning of paragraph 94, it's not in fact accepted by the judge. and therefore you submit. All that's left on this point is the fact that it's become superseded by events.
Yes.
See paragraph 93.
Yes.
And you say that was wrong.
Yes. The reasons I've already given, and that is my whole positive case on this ground.
Yeah.
My learned friend in the respondent's notice says that the judge was wrong to find illegality, and the basis upon which he puts that forward is that the council's constitution requires attendance at the site visit.
Yes.
And to be clear, it is not in dispute that the council can lawfully have a constitution which requires attendance at a site visit as a lawful precondition of voting. That would not be consistent with the very recent judgment of the Supreme Court in Spitalfields to mount submission contrary to that. So that's not pursued, nor was it submission made below. But my submission is that the Constitution requires attendance at the site visit. Councillor Price did attend the site visit. He left early. He left,
yes,
on my evidence, 20 minutes early. The judge points to the contradiction in evidence.
Yes.
That does not mean he didn't attend the site visit. And in
just take this in stages. If there's a factual dispute, somebody says 20 minutes, somebody says 1 hour, how are we to resolve that?
You can't resolve it. The judge doesn't resolve it either.
Okay, so on what factual foundation should we therefore proceed?
That it was either 20 minutes or an hour, and that it can't have made a difference for the purposes of the respondent's argument, because it's the respondent who puts forward this submission. It's their respondent's notice, it's their case to make.
Right, okay, and even assuming that it was only 20 minutes, what's wrong with the local authority saying you weren't there for the whole time, and therefore you can't attend the meeting?
Well, in my submission, it is a judgment for the member themselves, not for the chair of the committee to form a view on that, and the judgment reached by the member can be informed by advice from the monitoring officer. So once there has been attendance, whether or not leaving early results in an inability to vote is, in my submission, not a matter for Councillor Brodie. It's a matter for the member with the advice of the monitoring officer. That's my submission in response to the respondents.
I thought you were going to make another one, but I don't want to put words in your mouth. I thought you were going to say that the respondent's notice is premised on the fact that the requirement of attendance is a standing order and that it was breached. And I thought you were going to tell me that if I looked at the website, which I did yesterday, standing orders are in Part 5 and the guidance to members are not standing orders. And that confirms your point that it's for the councillor, not for the chair of the committee to decide it, but you're not running that point.
I certainly haven't run that point in...
You need to look, somebody needs to look, Dr. Bowes needs to look, because when I read the respondent's notice, I thought it wasn't actually accurate to say that it's the standing order, because they seem to be defined in Part 2, and they don't seem to include the guidance. But Dr. Bowes will tell us that I've made a mistake about that.
I confess that I had taken the council's pleaded position at its word, and I did not separately investigate the council's website, and we did not have evidence below on that, I have to be frank.
Right.
Dr. Bowes will tell us whether or not it is a standing order or not.
I shall.
And my lord, those are my submissions on ground 4.
Thank you. Is there anything else?
Unless I can be of further assistance.
Oh,
No.
so in fact, we're doing very well on the timetable.
Yes, my lord.
Thank you very much. Yes, Dr. Bowes.
My Lords, good afternoon. I propose to deal with that tomorrow because it'll fall under ground 4. It'll then also enable me to double check that point.
Double check Part 2. I think it's where they define it. They say standing orders that are, I forget the ones, it's the ones about you as a committee, and that's reinforced by the division of numbers, because it starts with a new set of numbers, and then when you look at the thing that you say is part of the Constitution, which it is, but it's not a standing order apparently, it begins guidance to members rather than the words you expect of a standing order. But I assume you know your rules, and your councillors will know your rules, and you'll tell me why I'm wrong.
Well, we will entirely check that. The other point just to be aware of is the Constitution has changed since the material dates at issue
they
here.
give 4 versions on the website, so I went to the one in force of the material time.
Well, then I will check that, my Lord, overnight, if I may.
Thank you.
Okay. And what I propose to deal with this afternoon then, in the commendably economical way my learned friends dealt with his submissions, is to deal with timing, the discretion, the Burket point first, then hopefully complete the whole of ground 1, and with a fair win ground 2, but certainly make a good start on that. So that's my roadmap for this afternoon, and then deal with 3 and 4 tomorrow, which will give me the opportunity to check overnight the standing order. If that's sounds a sensible way of proceeding, I'll start with timing.
Thank you.
And as my learned friend quite properly foreshadowed, the range of dispute between us here is that there's no dispute that under a judicial review, under the Planning Acts, a claim form must be filed not later than 6 weeks after the grounds first arose. So that's the relevant procedural requirement under the CPR. And the dispute is whether we're in that time for the purposes of grounds 3 and 4 of the appeal. And I want to make this clear. I'm now making this point that it is fairly focused on 3 and 4. I'm not going to pursue the point about ground 1. So this is about 3 and 4. And grounds 3 and 4 factually turn entirely on events at or in the lead up to the July 2021 committee. And the claim form here filed a long time after the relevant 6 weeks from that resolution. No dispute about that. The question is whether the force of Burket allows you to count that resolution to vitiate this grant of planning permission in August 2023. And in my submission, the submission I'm going to make, and I want to take you to Burket, is that's taking Burket too far, because what it doesn't allow you to do is challenge a public law decision on the basis of any antecedent decision. It is only where that public law decision or measure is contingent upon or reliant upon an earlier decision. So that's the submission I want to make.
I think what's said against you is that it's not simply a chronological point, but it's an antecedent, but that it was expressly said to be a material consideration in April 2023.
Well, first of all, as the court's pointed out, it is lawful until it's quashed. That resolution was a public law decision of the authority, capable of legal challenge. So one could, in appropriate circumstances, bring a judicial review of a resolution of a planning committee, notwithstanding that one might be able to wait. So that's a public law decision of the authority, which is amenable to judicial review and has not been quashed by a court of competent jurisdiction.
Yeah, but the House of Lords knew that and said that in Burket.
Yes. But in Burket, and perhaps if I can take you straight there, so where this passage is, because this situation was contemplated by Lord Singh. And it's page 24 of the authority bundle, so tab 2 is Burket, page 24. We're here, my apologies, in the judgment of Lord Steyne, the speech of Lord Steyne,
Yes.
at paragraph 39.
Yes.
And here, just below the letter C, Lord Steyne is explaining some of the rationale for why you don't take a resolutions-based approach, because he says, until the grant of planning permission, the resolution has no legal effect. It is unlawful for the developer to commence any works in reliance on the resolution, and a developer expends money on the project before planning permission is granted at his own risk. The resolution may come to nothing because of a change of circumstances. And then look, if you just follow 2 sentences down, after the resolution is adopted, the local authority may come under a duty to reconsider its decision if flaws are brought to its attention. And in my submission, that is where we are. There was a resolution of this authority in July 2021. Flaws, or alleged flaws, were brought to its attention by the appellant company through its solicitor in a pre-action letter of 2022. The authority then, in the fullness of time, takes that back to its committee, and it is on the basis of that resolution which it grants planning permission, and that's expressed on the decision notice. Perhaps I just need to show the court that. Sorry, my lord.
We haven't seen, oddly enough, the resolution from the meeting of the 25th of April 2023.
No.
But from the motion, it can't have been the sole basis, because the motion doesn't refer to the Section 106 agreement, but the earlier resolution does. So I do wonder whether you really got to read the bits in the supplementary bundle, which is what they did, which was to approve the application again,
Yes.
even though it had already been done once.
Yes.
But it wasn't a fresh resolution covering everything, because it didn't, for example, say the officers will go and do a Section 106 agreement. But I haven't seen the resolution. I've only looked at the description of the motion that was put. And there's discussion, as you will recall. I don't know if my Lord, it's right at the very end. It took me 2 days to get to it.
You have that at 336.4.
336, is it?
Point 4. You have the 2023.
Rather odd that the resolution, which is the decision, isn't there, but it doesn't matter, but it's 336. Because when I looked at that, well, the motion is Ms Wilkinson does various things. And where's the actual motion?
At the bottom of the page on 336.4. See, a proposal to agree. A named vote was requested, the result of which was...
336, I just haven't got it, I'm sorry.
Oh, sorry, my lord.
I've got 336, where?
Point 4, so 336 additional pages. So these were clipped.
Oh,
these were inserted.
Dot 4.
Dot 4.
Oh, I don't have those, no.
Ah, right.
Oh, hang on.
There may be.
Oh, they're over. Oh, we do have the minutes then, yes.
Yeah. Interestingly, this has 4 page numbers on it,
Yes.
which I think Sedley's Laws of Documents said that every document should have 3
Yes.
numbers on it.
That's
but
Sedley's Laws of
it's
Documents.
4. It's got 1377.
That was from the
Is
original
that
trial
actually
bundle.
the continuous pagination?
From the original trial bundle.
From the original
of
trial
which a lot of the material isn't before
I see.
this course. No criticism, it doesn't need
And
to be.
which passage do you want us to look at?
So, if you go to the bottom of that page, you see a proposal to agree. Do you see that?
Yeah, I see
A
that.
proposal to agree with the officer's recommendation.
That is the, yeah, I've got it now, yeah.
And the officer's recommendation was to grant planning permission subject to a 106 agreement.
Yeah.
Yeah, this is the 71%.
Indeed. So there was a difference.
Yeah.
Was a difference.
That's what I thought. I thought it was this resolution which
Yeah.
was passed.
Exactly. And you can see who was voting for and against, one of which, and we'll come back to this probably later today or tomorrow, is Councillor
Yeah.
Price. So you've got who voted for what.
Yeah.
And then over the page, there's a little explanation of that, and then it says resolved, and then Councillor Medland rejoins the meeting, who was the chair for that meeting, but recused himself.
Yes.
Because oddly enough, the resolution is different from the recommendation is at page 299,
Yep.
and that is subject to
Yes.
the 106, but the resolution is that the application be approved, not that the recommendation be accepted.
So to agree with the officer's recommendation subject to, and the officer's recommendation, my lord, was to grant planning permission subject to 106.
Hang on, I'm looking at 336.5, which is the
Oh, there-
resolution. 336.4 is the proposal,
Yes, and then there's the
and the
vote.
resolution is at 336.5.
Yes.
Yeah.
And that doesn't refer to the section 106, does it?
No, it doesn't.
So-
But the resolution of the authority, which is faithfully recorded at 336.4, is to grant planning permission.
I thought that was the proposal that was put. These are the minutes. The proposal was
Yeah.
put. A named vote was requested. And the resolution was...
Yes. That's the proposal. My lord is quite right on the
Yes.
face of it. Where we see the actual resolution text is on, can I call it page 1378?
Yes.
All right.
Over the page, yeah.
Over the page, resolved that the application be approved, that should be approved. Yeah, in fact, there's several typos which then come into it. The application be approved again, subject to the additional 71%. I don't know where of 35% has come from. Affordable housing.
Oh, yeah, recommendation.
But as my lord says, there's nothing here about a planning obligation.
No, but the proposal that was put to the committee and voted on is recorded the page before. There's no suggestion there was another vote taken. So that is what the committee have voted on, and that recommendation, officer's recommendation, is to grant planning permission subject to a 106 agreement. So I accept that point, that the way it's been transcribed in that minute is in that respect not a full reflection of what has happened, because there wasn't another vote between the one that's at the bottom of 336.4 and the one over the page.
Okay.
And indeed, just to complete that point, if the court takes up the core bundle, you have the decision notice, so the instrument under challenge, which is at 247.
Well, that would help, because that would be based on either one or both.
Exactly, and that does help us a little, because if you go to 247, it tells us the authority under which it's granting that power, as one would expect in the normal way. So 247, 3/4 of the way down the page, in pursuance of its powers.
Yes.
The Isle of Wight Council, as local player, hereby give notice under the decision made on the 25th of April 2023 to grant planning permission in accordance with the application plans and particulars and subject to the compliance with the following conditions. So the basis of the instrument to issue the decision is the resolution which the court's just been looking at on the 25th of April 2023. That's how the council chose to express that authority to issue that instrument.
Yes.
And we've seen that that was perfectly appropriate, because that committee on that date dealt with the curlews and then decided to take another resolution. And that, take another vote. And that vote was to grant planning permission subject to the officer's recommendation, which was to grant it.
Not quite right, but it doesn't matter. You've got to read the words in the transcript.
But I'm not of the view that the appellant is just those minutes are inaccurate in terms of what was recorded and who voted which way. So we can take it that there was a full reconsideration and a vote taken on the underlying decision to grant planning permission or not. And that's what's faithfully recorded in the minute. And it's on that basis that the committee decision is expressed. And in my submission, that is a changed circumstances which Lord Steyne and the other members of the House who agree with that leading judgment had in mind in Burket.
Sorry, what are the changed circumstances?
That there's been another resolution, and it's on the basis of that resolution which the instrument under challenge was issued. So there's not a mention in the decision notice of the 2021.
But it may depend. If there's a new resolution, because everyone says, let's start with a clean slate. Fine. Mr. Streeton would say, I can't complain. But if you start not with a clean slate, but expressly direct yourself that one of the material considerations which you should take into account now is what you decided 2 years earlier, then why isn't he entitled to say, well, that's still having some operative effect on the thinking of the new resolution, and therefore if the earlier resolution is legally vitiated, I should be able to make that argument now, because there isn't a rupture.
No, well, obviously there's a band of circumstances which could lead to Burket applying and not applying. And I think it's common ground amongst the bar that there would be some circumstances in which, notwithstanding you've had multiple resolutions leading up to an instrument to grant permission, that there are some circumstances at least in which you can't challenge the earlier ones because there's been a reconsideration.
Yes.
So I think the legal submission I'm making to the court isn't actually controversial, which is that Burket does have a limit and you can't just go back to any earlier resolution.
Yes.
What the point that seems to be developed is a factual point, which is the degree to which the earlier resolution coloured or tainted, or however one wants to put it, the resolution upon which that decision was issued.
Can I put it this way?
Hello.
Suggest this to you?
Yes.
If it continues to play a material part, then Burket still applies.
If it continued to play a material part and it was accepted to be unlawful by this court, then Burket still applies. Because, of course...
But that's circular, because the whole point is there a time limit which bars you from arguing that something is unlawful? But if before we can decide whether the time limit applies, we have to decide whether it's unlawful, then what's the point of having a time
Oh, no,
limit?
I take my lord's point. Then, yes, that would be the answer to that proposition, which is that if the 2023 decision was tainted by the 2021 decision, then one can look at the 2021 decision.
Yes.
My submission on the fact of that is that it wasn't, and that the committee did take the opportunity that was available to them to reconsider it. And that's a factual position the court will have to come to. And the judge below, sorry, my lord, you had
I was just thinking, so the position was up until the 24th of April, they were fine because there hadn't been another resolution and they could have challenged the bias and so on. But on the 25th of April, when at the meeting another resolution was put together, they should have said, oh my heavens above, we better move quickly. We've got 6 weeks from today. We can't wait for the Planning Commission anymore. That's what you say happens.
Well, they would actually already have been out of time.
No.
And by the second resolution, they'd have been out of time to challenge the first resolution.
But they had no reason to challenge the first resolution because you accepted the first resolution was the thing that would authorise the Planning Commission if it were ever implemented.
Yes.
But in fact, the thing that changed was the unexpected proposal that there be a third resolution or a third vote on the 25th of April. So they wouldn't have been criticised for going to bed safe on the 24th of April, but they should have been terribly worried on the evening of the 25th of April, because suddenly, if they're going to challenge the earlier resolution, they've got to do it within 6 weeks. That's the logic of it. It may not be wrong, but that's the logic of your submission. They can't now wait for the Planning Commission. They've got to challenge the earlier things. And what's the purpose of challenging the earlier things?
Well, I accept that. What's the purpose of challenging it? Because there's been a second resolution. And if the court finds, as I'm advising the court to find, that that second resolution was a full reconsideration of the merits, certainly the officers did not tell members they couldn't look at the merits again. The chair of that committee allowed members to debate the issues more widely. There was a changed resolution in terms of affordable housing, nothing to do with curlews. If the court accepts that that was a reconsideration on the merits, such as the committee wanted to do, then that is a clean break and you can't go back. But I accept that does depend on that factual find. So I think where the bar has got to is that it accepts the legal proposition, but it's a factual evaluation where we're at a part.
Right. Just pause there.
Yes.
You would. If it's a matter of factual evaluation, then can I ask you the same question I asked Mr. Streeton this morning, which is, why should we retake the decision? We're not the court of first instance. The court of first instance disagreed with you about this.
It didn't, my lord. First, the judge below disagreed with me on the time point, on the Burket point, but he did make a finding that the 2023 resolution rendered the whole matter academic.
No, rendered some of it academic.
He says, can I just take the court to that? So 50, so it's 63 in the core bundle, you've got paragraph 93.
Yes, thank you.
And 93 is a separate finding to the one where he's making findings about highly likely to be substantially different, and 94.
Yes.
And at 93, in my submission, he was accepting the submission that I made to him, which is the 2023 resolution was a reconsideration. Perhaps if I just invite the court just to remind what the judge said.
Does he say it was a reconsideration?
It says, halfway down the page, says, while some of those who have previously voted in favour of the application were content to confine their contribution to the issue of the curlew habitat mitigation, it is clear that some of those who previously voted against the application debated its merits afresh. The officer's report was presented in detail with a recommendation the application should be granted. In my judgment, that was a proper process for which the court should not interfere. So, in my submission, I do stand by the basis that he did reject what I said on Burket, but he actually was with me on the factual point, which is that it was a reconsideration.
I thought the first sentence of that paragraph was your best point on that. In my judgment, those have been overtaken by events.
Yes.
That seems to be the closest he comes to saying that whatever happened in 2021, it's no longer important in public law terms.
Exactly.
Because it's been overtaken by events.
Yes.
But the answer to that, says Mr. Streeton, is he goes on to contradict himself because he says in the middle of that paragraph, members were advised the July 2021 resolution was a material consideration.
Yeah.
As soon as you accept that,
Yeah.
he says, it's not something that has been ignored.
Yeah.
So it has played a part.
Yes, although there perhaps is one further factual matter to draw to the court's attention, which is who participated in this 2023 meeting.
So who?
Who participated in this 2023 meeting. And you have those minutes.
Before we get to the minutes,
Yes.
we're in a danger here of turning this judgment into a statute. The first sentence says, to the extent, so it's not complete, to the extent that there may be criticisms of the procedure. And we know that ground one was procedure. It was essentially the affirmation of the 3-hour extension, and it was Councillor Price not being allowed to vote. And what he's saying is procedural problems at the hearing, at the first meeting, may now have been overtaken by events because there's been another vote. And you know why that is, because the 3 hours don't matter anymore.
Yeah.
You know, Councillor Price's absence doesn't matter anymore. He's there saying what he's saying. So the judge isn't really accepting your case on Burket. If we read all that he says on Burket, he says that Burket applies.
Yeah. Can I just show the court
Yeah.
one factual point there, which is
Yep.
just in the minutes where I was before.
Yep.
336.1, you have a record of declarations of interest. And it explains, first of all, Councillor Medland declared an interest in this item, the Westacre Park item, as he contributed to the crowdfunding for the judicial review regarding this application, and he'd leave the room. So he's out of the picture. But over the page, Councillors Adams, Spink and Quirk declare the same interest, and for their own reasons and evaluation, they don't leave the room. So they participate in the meeting. And these are people clearly highly interested in this judicial review claim because they're contributors to it, and can be taken to have understood and be aware of whatever procedural flaws, criticism and complaints were being levelled at the authority through that claim, because they're people not only interested and sympathetic, they're actually funding the litigation. And then you see them take part and vote, interestingly, different ways, as it happens, at 336.4, on the, if I put it this way, the merits proposal. So insofar as it's saying, well, these people were tainted because they weren't told about the alleged criticisms and complaints about the 2021 meeting, 3 of the people participating were very well aware of that because they are contributors to this claim.
I don't know that I understand the significance of your point, I'm afraid,
Well,
in the context of Burket.
336. So I'm tackling at this point, my lord, the factual evaluation. So whether this resolution factually is a clean consideration, and whether members who participated were in some way not cleanly reconsidering it because they were not told of alleged procedural errors in the last one. That's the point I'm addressing. And my point to the court is to say, well, you can't say that about 3 of them, at least, because they're people participating in this claim, or the funding of this claim. So they are very well aware of what criticisms were being levelled at the July 2021 resolution, because here they are declaring their interest and participating.
I really don't understand the relevance. All I'm saying is there was a ground 1 which was certain procedural errors.
Yes,
3 hours, Councillor Price absent.
yes,
93 says, to the extent, presupposes not the entirety of what went on. What is that extent? Criticism of the procedure. What is that a reference to? Councillor Price in the 3 hours. He's not saying, as I thought you were saying, the judge said, that the whole thing was afresh. He wasn't. He was saying the reverse. Save to the extent of the procedural issues, the thing was looked at again. And the real question is to look at the paragraphs on Burket.
Yeah.
Anyway, that's
Except-
it. Yes.
I do just need to tackle this, except his finding in the middle of that paragraph. It was clear some of those who have previously voted against considered the act debated its merits afresh. So he did make that finding. So I am entitled to say that the judge below made a finding that people participating in this committee meeting took the opportunity to debate it afresh, including those who voted against last time. So I think I am entitled to put it that far, my lord. And as I've said, I don't detect there is a dispute on the law here, which is that there is a limit to Burket, and that if you had a hypothetical other situation where it was accepted that there was a second resolution that in some way wiped the slate clean or it was a reconsideration of the issue, well then Burket wouldn't apply. And that must be right, because otherwise an authority could never correct, ever,
Yes.
the issue. And of course it's the invitation of this appellant that it goes back to the committee.
Because paragraph 59 is the key judgment that you have to persuade us he got it wrong.
Well, he says it's not a distinct step in a multi-stage process, and I accept that. And the basis why he's saying that was a Court of Appeal authority that said Burket had its limits in multi-stage consents, multi-stage processes. So I'm not taking issue with that. Then he says in Burket's there were two preconditions to the grant, whereas here there was only one. But like Burket, the grant was conditional upon the signing of the 106 agreement. Well, that's true. The reason officers did not issue the grant under delegated authority, which they could have done, was that it had been a difficult application to manage, and they did not think it appropriate to do so. Instead, they asked the committee to reconsider. Then Natural England raised the curly point. The July 21 resolution was considered by officers to be a material consideration in that grant. In my judgment, this challenge has been brought within time and properly includes within its compass the criticisms of procedural and other irregularities in respect of July 21 meeting. Whether subsequent events renders any such circumstances academic is another matter, and we've been dealt with after the grounds have been considered in substance. Well, the issue with that, my lord, is that, as I think I've explored with the court a moment ago, Burket has a limit to it, and that limit has a factual evaluation that's required.
Yes.
So if you had a situation where there was a second resolution which did indeed render the facts academic, the complaints academic, well then surely Burket would apply. So I do criticise the judge for saying, well, that's a wholly separate matter that doesn't bear on my consideration.
Well, I'm afraid I don't read the judge as disagreeing in principle with that. I think what's crucial is the sentence before, which says the July 21 resolution was considered by officers to be a material consideration in that grant.
Yeah.
And it's actually stronger than that. Because again, I agree with my lord that one should not read a judgment as if it's a statute. It's clear what he's getting at, because he's cross-referring back to what he had said at paragraph 40, in the final sentence, where he said it wasn't just that the officers considered it to be a material consideration, but more relevantly, the officers gave that advice to the members. They said that that determination would be a material consideration, and it was ultimately a matter for the committee to decide how to proceed. So, as I read his reasoning, what the judge is saying, taking all of that together, is that you may well be right, that if you can show there is a clean break with an earlier resolution, Burket does not apply.
Yes.
But here he thought that there was not a clean break,
No.
precisely because the committee had been advised by officers that the earlier resolution was a material consideration now.
But it was, and it couldn't otherwise be. If officers had told members that you resolved in July 2021 to grant planning permission, you should ignore that when you're determining this application because it's legally irrelevant. That is an error of law, because that resolution of the authority has not been challenged or quashed. And this court, or the High Court, may have had other points about it subsequently, but at that point they couldn't have told members.
Is that right? What would be the position if, let's not this case, but just to test the principle. Suppose solicitors for the claimant write a pre-action letter
Yes.
to the local authority,
Yes.
and they think, actually, you're absolutely right.
Yeah.
There is a legal problem
Yes.
with our resolution of 2 years ago.
Yes.
And so they, instead of waiting for expensive
Yes.
and time-consuming court proceedings to quash their decision, they take it back to their committee and say, ignore the earlier resolution because it's legally flawed.
Yes.
Why couldn't they do that in principle?
Well, perhaps if I clarify my answer by saying, in a case where there was an attack on the substance, so say there were 2 paragraphs in the officer's report which said something that was legally wrong about the meaning of a policy, and pre-action letter was sent and said, you've got that wrong, here's the decision of the Supreme Court saying it means the opposite of what you've said. In that circumstance, you could go back and say, we've made this error, we accept there's an error, appreciate it's not been quashed, but we can see the force of the argument, so reconsider it on this different basis. In a procedural objection, you can't really do that, because the best you could do would be to take it back and have it reconsidered on a procedurally appropriate basis. So perhaps there's shades of answering my Lord's question, because in that situation you can obviously see how you could correct it, because you'd say ignore paragraphs 23 to 25 because they were bad advice. Here's the right advice. Okay? But in a case where the complaint is, well, this councillor was excluded, there was an appearance of bias in the way it was being chaired, well, what more could they do than redetermine the application? And that's what they did.
On its substantive merits.
On its substantive merits, which in my submission is what they did.
That's why the judge says that may make the earlier challenge academic,
Yes.
but not why it makes it out of time, which is what Mr. Streeter said at the beginning, I think.
And I accept they're two different things. I accept that. But they are interlinked. And I don't detect there's actually a dispute about that, in that if you are assessing, for the purposes of Burket and time, whether the later decision renders the earlier one academic, well, obviously there's a factual evaluation to be performed there. So insofar as he was considering whether something later renders the earlier one academic relevant to Burket and timing, well, he was wrong to do that in my submission, because obviously there's an evaluative exercise the court performs.
But the one question for timing is there a link between the first resolution and the second resolution?
Yes.
And the judge found on the facts, yes, there is. The next question is, right, you're in time now, you can challenge it.
Yeah.
What is said to have gone wrong here? And the answer is, somebody wasn't there at the first meeting and he should have been. Next question, was he at the second? Oh, yes. Does it matter then? That's all that Mr. Streeton is saying with timing and academic.
Well, I would accept that with this one qualification, if I may, my Lord, which is that the question that arises from Burket is there a link between the resolution you're challenging and the decision under challenge in the judicial review? And that's what you'd have to find a link to, the August instrument that's under challenge in these proceedings. It's not good enough to say, well, I found a link between some of the other resolutions. You'd have to find a link between the July 21 resolution and the grant of planning permission, which is the single public law decision before this court under challenge. So I would accept it with that clarification.
And you're not impressed by the argument about the clear link is the section 106 agreement comes only from the first resolution, not the second resolution.
Well, my Lord, I don't accept that, because it said it says 336.4. There was a proposal put.
Yeah.
And you see who votes on it.
Yeah.
And that proposal is to agree with the officer's recommendation. And that recommendation was to grant planning permission subject to the 106. And it's not actually taken against me that they therefore issued planning permission on a want of authority basis, which would be the legal conclusion of what my Lord's putting to me.
No, because I'm relying on the resolutions, not the description of the vote, which may or may not be accurate. And the vote and the resolution doesn't refer to 106.
No, but there was no further vote taken between those two things.
We've been down there, let's worry about that again. Yeah.
No. So in my submission, my Lords, the way to conceive Burket is accurately encapsulated by the way Lord Sales puts it in filed. And the court was taken there this morning. And perhaps if I can just give you one reference, which was para 36 in filed.
Shall we just have a look at that again? Just so I can be entirely clear.
Yes.
What your submission is.
So you
have
have
is
tab 26. Paragraph 36 on page 514.
Thank you.
And to save my learned friend saying this in reply, I accept this was a case about statutory time limits challenging neighbourhood development plans, orders and ancillary decisions, where there is a bespoke and very complicated scheme about when you have to challenge them. That's not this case, self-evidently. What I rely on is the observations at 36, where, in my submission, accurately, the majority of the Supreme Court is encapsulating the way that you approach this. The act of a public authority is taken to be valid and effective unless it's challenged and quashed by legal action taken in proper time. However, where a public law measure is taken at the end of and on the basis of a series of steps, and its lawfulness is contingent upon the lawfulness of each of the steps leading up to it, a question may arise whether the lawfulness of the final measure can be impugned by a claim brought within time, assessed by reference to that measure by showing that an earlier step was affected by unlawfulness. even though the claimant would by then be out of time to challenge the lawfulness of the earlier step if taken by itself. And in my submission, that is an accurate encapsulation of the Burket principle in modern administrative law today.
Right.
And you see at 515, over the page, para 40, Supreme Court cites Burket and says, a case concerning a challenge to the grant of full planning permission on the grounds of unlawfulness regarding the environmental impact assessment on which a prior resolution to grant permission had been based. Had been based. So in my submission, that there is an outer limit of Burket, accurately identified here by the Supreme Court, and when applied to the facts of this case, means 3 and 4 are out of time. I accept that relies on the court making a factual inquiry into the link between Resolution 1 and 2 and then the link between them and the Planning Commission. But in my submission, that link is severed by the 2023 meeting, which was itself on invitation of the appellant company to take the decision again. So those are my submissions on time. And I'm going to switch now to deal with ground 1.
Thank you.
And you'll have seen that the judge below found this point to be unarguable. So this was a rolled-up hearing for judicial review. Permission had been adjourned into court, and the judge found it unarguable, and his reasons are at 73 to 78. In essence, we say the judge was right for the reasons he gave. And I have 3 components of my submissions on this. First of all, point 1, there was substantial compliance with the duty at Article 40. So point 1, there was substantial compliance. Point 2, even if I'm wrong about that, there was no material prejudice. That's point 2. And point 3, there is no difference to the outcome, even if the error of law had not occurred. That's point 3. And my lords, I get substantial compliance from Singh. You were taken there this morning. Does the court want to go back over Singh? I think the principle was fairly encapsulated by my learned friend. One asked the question whether Parliament intended a breach of the measure to lead to automatic invalidity. If not, you look at a range of factors, including substantial compliance. I don't think that's in dispute. So I don't think we need to go back there. I'll just make this submission, though, in case this isn't accepted by my learned friend, which is that in my submission, the DMPO, as a statutory instrument made under powers under the Town and Country Planning Act 1990, is not an instrument in which it can be fairly said Parliament intended any breach of its provisions, including Article 40, to lead to the automatic invalidity of a subsequent measure, i.e. a grant of planning permission. And the court's been taken to a series of first instance judgments where judges have, notwithstanding the fact there wasn't compliance, nevertheless not quash the measure. So in my submission, that's not the consequence. So the court is into the territory of asking person, e.g. whether there has been substantial compliance with the obligations in Article 40. My lord, in my submission, Article 40 is not requiring the publication of the 106 draft for the purposes of inviting a consultation. What it's doing is an alert provision. It is putting the 106 provision on the planning register to alert people to see whether they do want to comment on it. And I say that because there's no time limit prescribed in Article 40 for how long it needs to be on the planning register. And if it were seriously being said that the purpose of Article 40 for putting the 106 on the planning register was to invite a consultation exercise per Moseley, per Gunning criteria, per that type of consultation, well then one would have expected there to be some kind of time limit, timetable in which consultation remarks could be received. So in my submission, the purpose of Article 40 is to alert people to the fact there is a 106 and its contents, such that if they do want to comment on it, they can. It's not
to
invited.
enable people to know it if they wish to comment upon.
Precisely so, my lord, yes.
It's not. It may be a question of terminology. I think what you're getting at is not so much a time limit, but a deadline. But there would have been a deadline.
Yes, that would be a much better way of putting it, if I may say so, my lord, yes. So like, for example, you see the consultation requirements on a grant of planning permission must be at least 21 days. Often they're much, much longer than that, but it must be no fewer than 21 days. That is clearly a consultation exercise in which gunning criteria would apply.
Well, take an extreme example. The night before they issue the notice, the draft has been produced and the developers roll over and sign without a quibble, amazingly.
Yes?
It would be published at midnight.
Yep.
Planning permission, 8:30 that morning when the senior officer gets into work. No breach. They didn't have a draft before. They were stunned that the developers
Agreed.
gave in.
Yeah.
No breach.
There wouldn't be, no. And I'm supported in that submission, my lord, just to take that a step further, in that once there is an executed 106 agreement, the authority has no further public law function to discharge but grant planning permission.
Yes, but you could have, that's why it's entered agreement. There will still be the period between entering the agreement, or could be a period between entering the agreement
Yes.
and signing it, and they could write in and say, no, the heads of agreement were supposed to cover 6 things, including
Yes,
heritage.
exactly.
It only covers 5. Don't issue the notice and go back and get the 6th thing. That could happen.
That could happen.
Yeah.
That could happen.
So it's to enable people to know, and if they wish to comment upon
Yes.
a draft or final Section 106 agreement.
Yes. And that's to be seen in the context of a bundle of broader statutory rights about access to background documents by local authorities. It's sometimes called a right-to-know provision, which is a term which the High Court has adopted in some of the Section 100D cases, a right-to-know provision, not a right to be consulted upon and have your view solicited, it's a right to know. So I would respectfully adopt the deadline characterisation rather than timetable, but I'd say that's a strong indicator that we're not here looking at a consultation procedure. We're looking
How
at
do you get to substantial compliance here then? You didn't put anything on the website.
No, except that we didn't.
There was no substantial compliance.
Well, there were heads of terms, and that's what I rely on for that.
And the point about they didn't have the figures in?
Well, they didn't have the figures in, but the heads of terms in the committee report clearly would have performed in my submission the core of the function, which was to know there was a 106 dealing with these things. The criticism here isn't, to take my Lord's example, there were 5 points, you've only dealt with 4 in the 106. This is a criticism to say, these were the heads of terms, you've dealt with them, but we didn't have the opportunity to comment on the content of one of those heads of terms as it formed into the agreement. Now, the answer to that is that substantial compliance was addressed because the function of Article 40 was met by alerting people to the fact there was a 106 agreement dealing with, amongst other things, highways, and amongst other things, the impact specifically on those junctions. If you want to know about it, you've got between the publication of that report and months later to make a request to see the 106 agreement.
You don't have to make a request. You can go on the portal. You're supposed to put it there.
Yes, we didn't put it there. We failed in that turn. The judge made a finding we were in breach. I accept that. No response notice about that. My point is the substantial compliance with Article 40 was met, i.e. people were informed there was a 106 dealing with these matters. Can I just show my lords the heads of terms so you can see the scope in which they were put? They're at 167 in the supplementary report, in the supplementary bundle.
Sorry, which page?
So 167, you have a heading recommendation. Here, just to make good the point I was asserting to the court without taking the evidence, the recommendation was conditional grant subject to 106, covering the following, and then you have point 1 as it happens, yes. A financial contribution towards, and then you've got those junctions that my learned friend properly took you to, junctions 4 and 5, alerted. So the function of Article 40, not met in form, accepted. Met in substance because somebody looks at that, no dispute this wasn't available, has 7 days before or 5 clear days before the committee hearing to make a request to see the detail, and then has the
detail before the committee.
Well, there wouldn't have been, but also
that just doesn't happen.
No.
They're not expecting to have the 106 agreement before the meeting.
No.
The whole point is the meeting, if they agree it, will authorise it subject to getting a 106.
Yes.
And the point of Article 40 is that if the financial contribution is £1.50, then they write in and say, come off it.
Yes.
If it's 400,000, maybe, they might write in and say, well, what about the other 300,000? So that's the point. They wouldn't ever have had 7 days and would have got the details before the meeting. That just doesn't work.
Save in a unilateral undertaking case, but
This isn't that case.
it isn't that case, accepted. But you then had the time, I can make this point, between April and August.
Well, you can look at the portal and see when it's coming and you know what's on it, yeah.
Well, there's no requirement to say when it's coming. The requirement is to put it on there.
Yeah.
So they could have said in that time, you've resolved to grant planning permission on the back of a 106 agreement, which says what it says. I want to see that draft.
No, they could have gone to the website every morning and thought, it's not there yet. We're in the clear. That's what they could have said.
Well, that would mean, if that's the construction the court approaches in my submission, that would mean that Article 40 is a strict liability provision, if I put it that way.
It is, it tells you what your duty is.
In that if you don't comply with it, the instrument that's contingent on compliance is invalid. And in my submission, that is clearly not what Parliament
You
intended.
keep saying they had 7 days to ask for it. They could have asked for it. They don't have to ask for it. The duty is you should have put it on there.
Yes.
There's a degree of compliance in that they know the heads of terms, but they don't know the amount. And the next question is, what are the prejudice?
Yes. So my first submission is there was substantial compliance, or I can put it this way, there was a degree of compliance, which I say was substantial.
Yeah.
And I do have some support from that from Davis. My lords were taken to Davis, obviously a decision that doesn't bind this court, but a finding of the planning court, specialist court in this field, that putting heads of terms on the website as a matter of principle.
Figures in there.
Yeah. But as a matter of principle, putting heads of terms is a basis on which compliance can be found to be substantial and to avoid a quashing. You're then on to, if you're not with me on that, when you go away and consider it, is whether there's prejudice. And I am entitled to say that if there was a case where there was no material prejudice, well, even though there was no substantial compliance, highly unlikely that it would be proper to quash a grant of planning permission with all the contingent public interest around granting planning permission. So, can I then turn to address that?
Sorry, just before you leave that.
Yeah.
Can I just ask you to pause there?
Yeah.
For where we are in the analytical framework when you
Yes.
make that submission. Is that a submission based on the Senior Courts Act, Section 31? Or is that some prior principle of law before you even reach remedial discretion?
Yeah. I would, in my submission, it is a prior principle of law in that if I'm right to say that the DMPO does not, on a proper construction, mean automatic invalidity, and when there's a breach, part of your assessment about whether you find an error of law is whether there's material prejudice.
If you look at the extent of compliance and the harm that's been caused by the extent of non-compliance.
Yes, that's how I would put it, my lord. So I would say it's a prior, before you reach the statutory Section 31 provisions.
Yeah. Thank you.
And on that, my lords have another High Court authority where this point was considered, Worcestershire.
Yep.
So that was a case concerning similar provisions, but in the primary statute. So in section 100D about access to background documents. So different provision.
Where are we going?
So you are Worcestershire. Sorry, my lord, I should have given you the tab. Thank you. 27 is the tab.
Right.
And it's page in that report, law report 293. Sorry, the photocopying's cut off the.
293.
So the analysis commences at 292, which is where the judge, then Mr. Justice Holgate, was looking at section 100D of the Local Government Act 1972, access to background documents, under the heading legal consequences. He then cites Singh at 141, so this is a case where the High Court was taken to that principle,
Yeah.
and then he applies it, and he says at 142, on true construction of that Act, he doesn't think a failure to comply in relation to officers' reports or committee renders the subsequent decision taken by that automatically unlawful or invalid. And in my submission, if that's right for the primary statute, the 1972 Act governing committee decisions, it must also be right for the DMPO. Then we move on to substantial compliance at 144. And he says, in this case, there was substantial compliance with 101A. The existence of the 2018 appraisals was clear from the 2018 officer's report. I pause there. The issue in the case was about access to those viability appraisals. The key issue is whether there was material prejudice in relation to breach of 100D. The obligation to make the document open to inspection, which includes the existence of arrangements for producing a document to a member of the public after a request is made to inspect. Plainly, it's unnecessary for a request to see the document to have been made for a breach of 100D to have occurred. On the other hand, when it comes to material prejudice, a person who was aware of a reference in a committee report to a background paper, but was never shown or had any interest in inspecting the document, is highly unlikely to get very far in a claim for judicial review. So in my submission, there is a link between the contact between the people now complaining of a breach, which should lead, they say, to a quashing of this decision, and the conduct that they engaged in, so the appellant company engaged in, before. And on the facts of that case, different statute, but that judge was of the view that failure to request it meant it shouldn't lead to the quash.
I have some. I'm not sure about this. Just want to reflect on this because, as you've said, this isn't really like consultation requirements. It's more like a right to know provision.
Yes.
And it might be said, I don't know, but it might be said that these sorts of provisions are really intended to reinforce our democratic system of government, and that it keeps public authorities accountable to the public. So you may not have any material interests that you're trying to protect. It might just be that you have an interest in making sure that public authorities are behaving properly and not, for example, taking bribes or underselling things which they ought not to be taking a discounted price for in the public interest. You might be a journalist. You might be something. So why does the journalist who's interested in the local affairs of their area have to make a request for? Why do they have to be someone who's taken an interest in? Why can't they just say, the legislation says that I should be able to see this on a portal. It's not for me to have to request it. It's for them to have a duty to put it there.
Because I suppose the public interest in that instance cuts both ways. There's a public interest in transparent decision-taking, but there's also a public interest in public law measures involving the grant of planning permission, with all contingent public interests bound up in them, being preserved unless there is an error of law which has vitiated that permission and given rise to some element of harm. So in a case where, to take a different case, hypothetically, in a case where there was an officer's report with heads of terms and a member of the public showed no interest at all in any element of the decision or participating in it or asking to see the detail of those, and then months and months, maybe years afterwards, because there might be a delay in negotiating that document and the ultimate grant, there's then a judicial review claim. That, in my submission, on the basis that they didn't have access to the document, that, in my submission, is not in the public interest. Because why should, in that instance, the breach, albeit of a statutory duty, lead to the quashing of the decision? Those are two different
for this reason, the Worcestershire case was all about background papers prior to committee meeting, which had to be published 3 days before the meeting. Everybody knows the focus is on the meeting. You need to get them. If you can't be bothered in those 3 days to get the stuff to the meeting, you may or may not take a particular view on it. Yeah, it's different. There's been enormous controversy. There hasn't been a Section 106 agreement. It's looked at again in April 25th, 2023.
Yes.
The law is they will put the draft agreement, which has to deal with the contributions, on the website, and they haven't put it on the website. These people are interested in what's on the website. One of the things they want to say is, if the penny feather contribution goes, where's it coming from? And why should they not win on that simple basis?
Well, they shouldn't win on that simple basis for 3 reasons. In my submission, the compliance that did occur was enough to serve the purpose of the legislation. So that was the point I dealt with. Second point is, it is relevant in my submission whether there's been material prejudice to them. And thirdly, and perhaps I'll just foreshadow this point, which is that if I'm right about my submissions on ground 2, the penny feathers point, well then it's completely academic anyway. Just to anticipate where we'll go on this, if you took out penny feathers out of that contributory factor, you would obviously not have their financial contribution, but you would also not have their harm. And the costs of mitigating the Nicklenson Road and the Westacre, this scheme, was the total of the 2 that were left. So that it doesn't go anywhere at that point.
I've probably got the facts wrong because I don't know enough about the Isle of Wight.
Well, I haven't shown you
having
that.
visited and thought how lovely it was last year. But I thought the facts were that for the Westacre assessment alone, they thought it would cost for their mitigation proposal 770,000 roughly.
Yes.
And I thought that Miss Wilkinson's evidence, which I did find difficult to understand, said what they did is they added everything up because some of the junction would mitigate the Westacre harm and also the penny feathers harm, and they worked out what was fair between them. And it was 42% or whatever the figure was for penny feather. Now penny feather's gone, so you're going to have the whole of the harm, it seems, from the Westacre thing, but with only 400 or 700,000 pound cost. That seems to be what we're being told.
My lord, that's a very helpful indication because that's not correct.
Oh, right.
Actually, that's not correct. If you took out penny feathers, you'd be left with 2 contributions, as set out in that email, Nicklenson Road and Westacre, this scheme. The cost of those works was around 700,000. I'll take you to that in the material that you've got. The committee were told that, and they're the same junctions that are being improved. So if you took out penny feathers, you wouldn't have their contribution, you also wouldn't have their harm. You'd be left with contributions from Nicklenson Road, different scheme, and from this scheme. The requirements to mitigate those 2 schemes are the same junctions. The cost of those junctions altogether is 700,000. The cost of those residual contributions is 700,000. So that is actually the answer to it, factually.
Yeah, I haven't understood that because what I've been shown by Mr. Streeton and what I've seen suggests that there's a shortfall. There's the principal point. We're arguing about this. I don't live in the Isle of Wight, they live in the Isle of Wight. They wanted to know, as you were required to do by law, what the draft agreement said about the amount, so they could have written in and said, no, it should be more.
Yeah, and my answer to that, my lord, is they were alerted to it. They knew the 106 was dealing with that point. They knew it was dealing specifically with those junctions. And had they written and requested a draft of that agreement, that would have begun to form the base of a material prejudice in which it would have justified a quashing of the decision. Now, conceptually, whether the court gets to that conclusion through the prism of saying there isn't an error of law, or whether the court gets to that conclusion by saying there was a breach because it was compliance but not enough, but it's highly likely the outcome will be the same.
That's different.
That's a different point.
I think what would help me personally, I don't know about my lord, but I've got your submission that you think that the compliance was sufficient for it to be substantial.
That's point 1.
You've got, as part of the prejudice, the fact they didn't write in is material to assessing the prejudice.
Yes, that's point 2.
But critical is, I seem to think at the moment that part of the general principle of prejudice is they would have been able to comment on the amount. And I've also got it fixed in my mind that there's a difference once you take penny feathers out and the figures may be different, and that reinforces the practical need to write in and say, hold on a moment, don't sign that, go back to Westacre and ask for more. And that's where I'm stuck at the moment.
Can I take that second point first, if I may?
You can, but I just want to flag up that I have a different concern.
Okay.
Which we are going to have to come back to.
Yes.
Shall I explain what my concern
Please do,
is?
my lord. Yeah.
I don't think the only problem is penny feathers. Even if you're able to meet ground 2, I'm not sure that disposes of ground 1. And I'll explain why. Because one of the reasons why you have procedural requirements is to improve the decision-making process. So even if the outcome would be the same, the process needs to be lawful. And one of the reasons for that is that people need to have confidence in the process. They need to feel that they've been treated properly, that they've had a say, that when legislation gives them the right to have a say, that they've been given that right, even if, at the end of the day, the decision will be the same. Now, what Section 31(2)A has done is, to some extent, at the remedial stage, it's imposed a duty, where previously there used to be a simplex discretion. But I think, conceptually, before you get to questions of remedies, you have to decide whether there's a breach of the law.
Absolutely.
And I'm not myself persuaded that just because the outcome would be the same, there isn't a breach of the law.
Yes.
When it comes to procedural requirements.
I'm not going to persuade my lord otherwise. I'm not seeking to.
Okay, all right.
My submission is in 3 parts.
Okay.
First 2, no breach of the law.
Yes.
Final 1, if there is, highly likely to be the same.
Yes.
And if my lord's putting to me the proposition that the process bears, the fact the process might have been different but the outcome was the same, bears on the exercise of 31(2)(a, well then I need to take my lords to what this court said in Goring.
Yes.
And you don't have that, because that point's not been taken against me, but I can show what this court said in that case about the focus of section 31 is on outcome.
That's fine, very fair.
But that's a different point.
But what I may not have explained myself enough. Leave aside any questions of remedies.
Yes.
Because that only arises if the court has first decided
Absolutely.
that there's a breach of the law.
Yes.
When it comes to this concept of material prejudice, speaking of myself only, I think there can be material prejudice where you have not, where you've been deprived of the opportunity to have your say. That's the prejudice. Even if, once you'd had your say, they would have reached the same decision.
Yes, they're conceptually different things, and I accept that.
Yeah.
I accept that. And the court's performing a different intellectual exercise at those different
Yes,
stages.
that's all I wanted you. So the reason I say that the answer to penny feathers may not be a sufficient answer to ground 1 is that it even if on the facts it'll turn out that it wouldn't have made any difference, I'm not sure that is an answer to the residents of the Isle of Wight who feel that they haven't had their say.
No, it wouldn't be an answer to the error of law.
Yes.
It might be an answer to whether ground 1 led to the quashing.
Precisely.
And I accept that.
Okay.
I'm not disputing
That's
it.
fine.
So I was addressing points 1 and 2 of my 3-point answer to ground 1. Points 1 and 2 are purely on whether there's a breach of the law.
Yes.
And I've dealt with what I have to say on substantial compliance, and the court's got my submissions on
We've
that.
got that.
And that turns really on what you make of the committee report.
Yes.
My view, it performs the function of Article 40. What's said against me is, well, you didn't put in the figures.
Yes.
And that's an evaluation for the court.
Yes.
Point 2 is to say that even if I'm wrong about that, there was no material prejudice. And what I'm addressing here is on the law purely, not on the residual discretion.
Yes.
And in my submission, it is relevant when you're looking at an instrument like the DMPO, which doesn't prescribe a consequence for breach, to ask whether there was material prejudice, because that bears on this court in its objective exercise in understanding what Parliament would have thought the consequence would have been had it turned its mind to putting in an Article 40A, for example.
Yes.
Something like that.
Now, does Singh actually say that?
It does.
It does actually. Those are two factors.
It does, yes.
When you're assessing, you look at the degree of compliance and the extent of the prejudice.
Yeah, exactly.
Yeah. So it's not just first instance authority.
No.
This is binding House of Lords authority.
It is, yeah.
Yeah.
So,
So far, so good.
And-
so there seems to be no issue between the parties on the legal principle.
on the legal rule book, if you like, to apply. And as it happens, a number of High Court cases have applied that general approach, some of which have kind of merged it with a residual discretion ground.
Well, that's the problem. There needs to be judgment saying that you've got to keep them
Yes,
separate.
and I venture to suggest this might be, there might be a comment or two about it, but,
Saying precisely that.
and that no resistance from us on that. They are different conceptual exercise, and the court's performing different things with different burdens. So, I accept that.
But the thing we're chopping at the bit to find out is, was there any material prejudice in the monies, pounds, shillings and pence sense before we consider the general principles of, well, they were allowed to have a say on the terms and they weren't given a say, but we haven't got to the pounds, shillings and pence yet.
Yeah, let me take you to that email, Law, where that's set out.
Yes.
Yeah.
Now, where are we going?
So that is 284, where my learned friend took you, where you've got those calculations and figures in red. And by way of introduction to that, those are the figures. You've got 184, where the committee are told the cost of mitigating the Westacre impact on its own. and that's 700 odd thousand. You've got that at 184. 777, nearly 800,000. 184.
Hold on.
Right.
Yes, it's at the bottom there, yes.
Yeah, so that's
Where it's come from,
that's
yes.
the figure for mitigating those junctions. And then when we look at 284, you
When
can
you say mitigating the injunction, that's actually not quite right, is it? Is this figures for mitigating their injunction according to their scheme?
yeah, they're the same junction. So Nicholson Road and Westacre, the works required are the same.
Yes, but
So-
the estimate is of the works that they are contemplating
Correct.
under their planning application.
Correct.
Right. So it's for mitigating in accordance with their scheme.
Yes, I need to correct my lord. So they're not contributing. That's the cost of doing their works.
The works that are described in the application.
Correct.
Not generally, if we want a good junction, how much would it cost, but how much would it cost to deliver the scheme in the planning application, and that's 700,000.
Well, including those junction improvements, it's their own assessment of these costs.
Yeah, we're at odds. It's not a trick question.
Sorry, my lord.
I just want a fact.
Yes.
Is the cost the works described in a planning application submitted by Westacre, or is it a cost by reference to a more general thing?
I think it's the latter. I need to check that, and I say that because they're highway works. So whether they're covered entirely by the planning application, I want to check.
Yeah, I think we are getting into the situation where no matter how the judge phrases it, the question is not getting across properly.
Sorry, my lord.
I want to know whether the planning application describes certain works, I don't
Correct.
care what they're called, and the figure for those works is 770,000.
Absolutely, that's my.
Or whether they're saying something different with, there are lots of people who want to do lots of works, the overall cost of putting in 2 lanes on junction 5 would be 770,000. Is it tied, is the 770,000 tied to a description of works in the planning application?
As I understand it, yes.
Right.
But I do want to check that, my lord. I understand those, though that is describing the junction improvement works necessary
Or
for
that
that
development.
planning application,
Yeah.
which I understand, my instructions are the same works as for the Nicholson Road permission scheme.
Right.
And you've got that at 284.
Right.
And you then see the 3 inputs, Nicholson Road, Pennyfeathers, Westacre. You know how much the junction works are. And my instructions are Westacre and Nicholson Road are the same works. And they've split them across Westacre and Nicholson Road. So if you took out Pennyfeathers, you obviously wouldn't get that half 1,600,000 odd. But you would not have the harm arising from Pennyfeathers either.
No, that's why I keep saying it
Sorry.
doesn't matter. If you've got to do certain works, it could be traffic lights, it could be a new road, it may not matter whether 2 developments are using it. There will be one set of traffic lights and somebody has to pay for them.
Yes.
And I'm trying to understand, did Miss Wilkinson, because that's the impression I get, add up all the developments, all the houses, total costs divided by the number of houses and got a figure? Because taking out the Pennyfeathers contribution doesn't automatically mean that that's okay, because the costs will automatically reduce by the same amount. That's the point, if you follow me.
I do follow that
Yeah.
point, my lord, but my answer to that is this, is that we know the cost of delivering the junction works necessary to enable Westacre and Nicholson Road to come forward.
Right, and what is the cost? You say we know it.
184, page 184.
The 770,000.
Yes, both junctions,
Yes.
770,000.
And on 284, where do we see a figure that gets us to 777?
By adding up Westacre and Nicholson Road, because that's how the costs were
In
spread.
fact, it's slightly less than 777.
Well, it's slightly less, but it's
Well, that may help you.
it is slightly less, yeah.
Yeah. But the important point for your submission, and I'm not saying I agree with it, but I just want to be clear I understood it, is that on page 284, if Pennyfeathers, which has the figure of 584 against it, 42.95%, if that drops out of the picture,
Yes,
then so does the need for that expenditure.
correct.
That's the point, isn't it?
That's the point.
Now, I don't know if that's right or wrong, but that's a very simple submission.
Well, that is a simple submission, and I don't think in and of its terms it's controversial that if penny feathers doesn't come forward, well then its associated harm doesn't come forward. That's obvious.
Yeah, but you can't put the associated harm is automatically equal to the cost that they're going to make.
Exactly.
The harm isn't necessarily equal to the contribution.
No, I accept
I look
that.
at page 168.
Yes.
There are 2 junctions that have to be changed because of this planning application.
Yes.
One is the Westridge Cross, and the other is the Smallbrook Lane and Great Preston Road.
That's right.
There are 2 things. And the implication, but it's nowhere set out in words of one syllable, that the planning permission that's been referred to in the planning report is a planning permission for developments at Marlborough Road, which in some way is connected to the Nicholson Junction. So there's going to be one development, definitely, that's going to be using one of the junctions. That's the Nicholson one.
Yes.
I understood from Miss Wilkinson that what she did for these 2 junctions was take the total cost for these 2 junctions of all that would be necessary. She added up all the houses for Nicholson, Pennyfeathers and West Cross and divided that in to get a figure.
Yes.
And you say the shortfall, even if you take Pennyfeathers' contribution out to 71,000, and I wonder where the other 511,000 of Pennyfeathers would have gone, but you will say it'll have gone things to do with their development.
Yes.
But there's still a 70,000 shortfall, isn't there?
There would be, yeah.
So why aren't they allowed to say, well, you've got to go back and say to Westacre, we're not paying more council tax for roads. Westacre are doing it. They were going to get it off the backs of Pennyfeather, but that isn't going to happen anymore. Isn't that something that they would have said?
Well, they might have said. They might have said that.
And isn't that material prejudice?
I don't accept that's material prejudice because there was they knew what the financial contributions were at once. They knew that there were financial contributions at 168. And also, they were told on the highways part of the report how that was approached at 152. 152, capacity and traffic impact. .148 on that page. As a result, the applicant has provided further junction assessment data. And then 6.149, these concerns are once again highlighted by Island Roads in relation to this application. However, a question is now raised in respect to the sustainability of recommendation for refusal. And, my lords, those references, 19.00921 and 19.00922, those are the Nicklenson Road.
That's assumed, yes.
Yes. So that's in the report, and then A for sure I in the public domain, because that's in the report. And then it's explained, 6.141, the aim is therefore to adopt this holistic approach, which will then lead to, which will pay out junction improvements on the basis of pooled contributions that have been sought from developers across this part of the Isle of Wight. So all of that is in the public domain, and then you're told at the end of the report, these are the heads of terms for these junctions. If someone doesn't show an interest in asking for that material, my submission is there's no material prejudice. Because the function of Article 40 is to tell people there is a 106 agreement, number one, to tell people the scope of that 106 agreement, and to give them, if they want to, an opportunity to comment. And in my submission, there was sufficient compliance with the policy behind that article to lead to the conclusion there wasn't an error of law, and in the absence of members of the public asking for that information, what's the material prejudice? Because if it was to be said that there was an unanswered question about shortfalls and all the rest of it, why wasn't that information requested between this report being published in the April and the grant of the permission in the August?
Well, they would say because they were waiting for it to go on the portal.
But they knew the 106 agreement was in train, they knew what it covered, they knew the junctions that it addressed, they knew that there was this approach with Nicklenson Road, because that's set out in the capacity bit of the report. They knew that the Highways Authority had raised this objection about deliverability, all the rest of it. So all the ingredients that found my learned friends ground 2 are in the public domain, save that the figures themselves weren't. I accept that. But the simple point to that is, if you'd asked the authority for that report, for that agreement, then there would be an argument about material prejudice.
Does Ms Wilkinson explain why the 70,000 is going to be taken on the chin by the council? I couldn't get it from her witness statement. She tells me, I think she's describing the planning report, and then I think she switches to the contribution. She doesn't give the dates, and it would have been very helpful if she had. But the impression I get is that she did it in the way I've described, divided it all, took the number of houses, divided that into the cost and said, right, you've got so many houses, you pay so much money, and that's okay, say that now there's a 70,000 shortfall, and this says the works would be funded. Well, they wouldn't be funded in total now, they'd be 10% short. And do we know anywhere either why she wasn't bothered by that?
Well, my lord, there's 2 points.
Yeah.
The first point is the answer I've given. And the second point is to say, which is the point of controversy, which I say I can raise, is about the enduring relevance of the penny feather scheme. And
Right, yeah.
I say I can raise that, just to tackle that point head on, because it was submitted to the judge below that it remained an emerging allocation. And the judge says allocation, he's wrong about that, it was an emerging allocation. But the underlying material which supported that allocation, and the fact that those councillors voted for submission of that plan to the Secretary of State, therefore concluding it was sound, bore on the enduring relevance of penny feathers. Now, that's recorded in the judge's judgment, so I do need to, because there is a procedural point taken against me on this. You see it 83 on page 62 of the core bundle. He says the response of the authority.
Sorry, which page?
Sorry, 62 core bundle. So judgment Paris 83.
Oh, sorry, I got the judgment.
So core bundle 62, judgment power 83, second sentence, recording, I say, the point being made to the judge that penny feathers had an enduring relevance, although the permission for the penny feathers had lapsed, it remained an allocated site. Factually, it wasn't allocated, but, and the judge wasn't told that either, but it was an allocation in the emerging plan. And then also you see at 86, my lord, the developer, who appeared below, drawing the judge's attention to the fact that transport assessment dealt with many different scenarios, including whether or not any impact mitigation would be necessary with or without the penny feathers development. So it was in issue, well, it was drawn to his attention.
This seems to be under the heading of whether the report would have been misleading.
Yes, and that's certainly how it was put.
And he says in his earlier part, when he's doing what is now ground one of the appeal, that the only thing they would have said would have been about highways, and he'll come back to that. But what we've got at the moment is one factually inaccurate reference to allocated and it's emerging, and another one saying that mitigation would be necessary with or without the penny feathers development.
Yeah.
The final chain in the link really is, or final link in the chain rather, if it's even approaching it on the basis that it's an allocation and an emerging plan, you don't know whether or not anyone's actually going to apply for planning permission or get it, or when, and when the money's going to come, do you?
No, well, 2 points on that. Well, first of all, the primary answer to ground 2, and thereby the final bit of ground 1, is that there was a mechanism to secure the funding for this scheme on its own without penny feathers. So that's the primary answer to it. The secondary answer to it is to say that penny feathers didn't cease to be relevant simply because the reserved matters element had been refused and therefore the permission had lapsed, because, as the judge below was being told, it remained an emerging allocation, and therefore the underlying assessments, including transport assessments and everything else that supported it as sound, remained relevant.
But the contribution won't be there.
Sorry, my lord, the contribution wouldn't
Won't
be there. No, but if it did come forward, obviously it would have to make its contribution. There's no dispute that if it comes forward, it provides works which obviate any adverse effect. That you have that, my lord, in the table in the transport assessment, that if Pennyfeathers comes forward and its associated works come forward, there is no adverse highways effect at any junction, including these ones. Would you like me to take you back? Can I just show you?
I don't understand that, and I don't understand the relevance of it.
Well, the relevance of it is this. It's that if one is entitled to have regard to Pennyfeathers, then it's relevant to say that if that comes forward, that will fund a more comprehensive assessment of works, which will mean there's no impact. So the mere fact that it hadn't been granted reserved matters approval and therefore lapsed didn't mean that Pennyfeathers fell completely off the table for two reasons. One, it's still an emerging allocation, but also two, the harm in this planning application doesn't arise on occupation, it arises after the 100th dwelling and after the 400th dwelling for the second junction. So taking those factors together, there is sufficient, certainly rationally sufficient, for an officer to say, well, I know it's lapsed and it's no longer got planning permission, but it's still an emerging allocation. The assessments are all therefore sound by the authority, and there is a sufficient time before the harm is realised for it to come back on stream and to fund works which are accepted, I'm just about to show the court where, would obviate any traffic impact. So that's why I say there are two limbs to what Ms Wilkinson did. Can I just show you the traffic impact point to make that good? So 65.2, coloured table, 65.2. Final two columns are the really ones that are relevant for this. Penultimate column, base plus committed plus proposed development plus Pennyfeathers. No problem. So if Pennyfeathers came forward and its associated contribution and those works, there would be no issue. That's the evidence. Second scenario, Pennyfeathers doesn't come forward. This development comes forward on its own with all the other committed stuff in the baseline. You've got a problem at junction 4. See the red. An important point for the court to note, my learned friend, I'm sure entirely innocently, says there was a finding of severe highways impact. Nowhere in this report does it say that.
But I know what he's saying.
He's a capacity.
It's nearly hit it, and if you put these houses there, there'd be a bit more, but it doesn't use the word.
Exactly. But the court will be familiar. They're planning policy consequences of saying there's a severe highways impact. That wasn't the evidence that was before them. But anyway, in the final column, Pennyfeathers doesn't come forward. You've got the impacts. It's them proposing those improvements, and you can see that you're then under 100% capacity. And those works are I understand, below the 770 odd thousand.
All three of the orange ones together.
No, they're alternatives.
They're no, but each one, because this is why it's impossible. We're not a planning committee, but you've got Westridge Cross with all of them, and it's going to be a problem in the afternoon. We've got the Nicholson Road proposal.
Yeah.
So that's only the Nicholson. Well, is it? I mean, without Pennyfeathers, and with this development and Nicholson Road, you're still all right, aren't you? According to this, you don't need any work.
Sorry, I don't quite follow that point. So just run that past me again. I'm sorry.
Box 4, it's Westridge Cross.
Yes.
And the problem comes when it's all of the developments, Pennyfeathers, Nicholson, and West Acre, whatever it's called, and in the afternoons there's a problem. If you go to the next box, that's the Nicholson Road proposal. And I don't know what that means in this context, but if you look at the base committed and proposed development without Pennyfeathers, so I assume that's what's there.
Yes.
And Nicholson and West Acre, there isn't a problem on the modelling scenarios.
No, it's approaching capacity, but it's not over capacity. That would be.
And is that because there's works built into the mitigation or not? It's impossible for us to, as a Court of Appeal, just work from this table to work out what the position is. The bottom line seems to be, Miss Wilkinson said, I added up all the houses for all the developments and I got a figure for each one. And you still haven't persuaded me that if you take out the houses from penny feathers, there's not a £70,000 shortfall. That seems to be the position.
So you accept those?
There would be.
It would be.
Yeah.
So the question for us then is whether, if, unlike my lord, I look not at principle, but at pounds, shillings and pence, whether I think £70,000 and they didn't have the chance to comment and say, go back and get them to empty their pockets a bit more was material. Is it as simple as that?
No, because there's another string to it, which is that if penny feathers came forward, there wouldn't be the impact, and it would be.
And this all depends on, you're all right to take into account the possibility, it's in the emergent allocation, somebody might apply, they've already had it once, they'll come up with a reserve matter scheme that meets, and then they'll only get it if they agree.
Well, someone had applied, got planning permission, sought reserve matters approval, refused not on the basis of highways or principle. It had then lapsed, remained an emerging allocation.
Yes, I know. But in order for any money to come in to fill up,
it would need to be granted permission and a 106.
Somebody would have to apply. They'll have to be granted outline and reserve matters approval, and it'll have to be subject to 106, which makes up the shortfall for building work that's already happened.
And however, that you don't have houses the harm accruing on occupation from this scheme. It only accrues for one junction on the 100th occupation, and on the other junction the 400th occupation.
So in 5 years' time, Penny Feathers 2 comes on the scene, and everything's hunky-dory, the roads have been built. Can the council get Penny Feathers 2 in 2032 to give up 70,000 for the works that have already been done?
It would have to contribute for its own works, and it is
I'm asking for the works that have already been done.
And it is lawful for the council to take a pooled approach to infrastructure. So, in my submission, yes, they could actually, because they'd say that was an infrastructure contribution. We paid out as an authority in advance the £70,000.
Right.
We're entitled to seek that back. And in my submission, that there's nothing unlawful about seeking pooled contributions to infrastructure.
So it is 70,000 material, and even if it is it overtaken by the fact that a further Penny Feathers development or similar might yield the money, and do both of those things, either or of those things, mean that there's no material prejudice when you do sonnage? Is that the analysis?
Yes, it is, because they would be in that scenario taking a pooled approach to infrastructure, which had been set out in public documents, and it's the basis on which they were seeking the contributions, and Penny Feathers would have its own impacts that it would need to mitigate, and it would not be unlawful for the authority to take that approach.
No, I understand that, but I'm not asking for money to mitigate the problems that they've created.
No.
I'm asking them to mitigate for work that was done 7 years earlier or a period of time earlier, which wasn't necessary for any Penny Feathers development at the time. It was necessary for Westacre, and you've told me that you would do it.
Yes. There may be, subject to the bounds of rationality, because there may be a temporal consideration around that, but in my submission, seeking a pooled approach to infrastructure in that way isn't unlawful.
All right, yeah.
And that turns on then application.
On the point about the fact that even if Penny Feathers has dropped out for the time being, that it could still come forward.
Yeah.
On that, you a moment ago, I think made the submission that it would be rationally open to a planning authority to form that assessment. And I can understand why you made that submission. But what I'd like to ask you is whether that's the test that we have to apply, because sometimes in public law that's the right test, which is, was it rationally open to a local authority to form an assessment? Sometimes that's not the test we have to apply, because we have to ask ourselves whether something is lawful or not, or has caused material prejudice or not.
Yes.
Whose judgment counts? Is it ours, or is it only a rationality review?
It depends on the question that's being asked. So the answer might be different for the different lenses through which one sees the grounds. So for the purposes of assessing whether it would have made a difference, in my submission, it is appropriate to look at the material that was before the officer and taken into account by the officer, was then advised for the committee, and if she was entitled to look at the penny feathers scheme and to see that that might come forward as a second element to our argument, well, that bears on whether you can find her judgment and the committee's judgment that accepted that irrational, which is said under ground 2. So in that basis, you are performing a rationality review. Yes.
But under ground 1, where we're in Synergy, where we're asking whether there's been material prejudice, is that a rationality test?
Well, in one sense, I suppose it is as well, because if you know what the committee would have done, or the council corporately would have done with the information if that had been put to them, then that does bear on whether, maybe less whether there's material prejudice, but whether the outcome would have been highly likely the same, which is a different test. Because if you know that if those points had been run and put to the council, and you know the council looked at them, well then, and it came to the outcome it did, well then you are in the territory of saying, well, it's highly likely the outcome would have been the same.
Right.
Because it's not as if the council was unaware of this point. That's the point.
That's the next question I was going to ask, and I hope it'll be the last one, because you've had such a lot of questions. But I've, as I've said a couple of times, had real trouble understanding what Ms Wilkinson did. And I'm looking at paragraphs 12 and 44 and 45.
Yes.
And I've written next to paragraph 12, which was considered when and by whom. When I read it, I thought this had now moved on to a post-resolution stage, to a contribution stage.
That's
the first thing I thought. The second thing I thought was that she had included, and the other paper seemed to make that out, at the time that she did this, the development that would have been posited by the now elapsed penny feathers development. So that's what I thought she was doing. The contribution, post-resolution, and including the houses that were included in the lapsed penny feathers development.
I see, yes.
And then I thought to myself, well, what's her explanation for doing that? And where do I get it? Because I understand it's pooling contributions from a single scheme for proposed development, but there isn't proposed development for penny feathers now. So why at this stage is she doing that exercise? Where do I find the explanation for that?
Well, the email where the figures come from is obviously a year earlier, so that's July 2022, and at that stage, obviously penny feathers was...
That's fine, that's why I've gone to the witness statement and asked you about that, which is much later, and why I've confirmed with you that when she wrote this in October 2023, we were at the contribution stage, not the pre-resolution stage, and you told me, yes, it was the contribution stage, and that was at a time when we knew that there's no penny feather 1 housing, and I'm just trying to work out why, from whether I know why that's what she did sometime after April 2023.
Well, why she did that? Well, for 2 reasons. One, that the contribution side of Westacre, coupled with Nicholson Road, wash the face of their impacts, and that contribution of 400,000 from Westacre was sufficient, coupled with Nicholson Road, to wash those impacts, and you get that from the email.
But I thought we've said that there was £70,000 short.
Yeah, so for that.
So it doesn't do that. So I'm asking myself why this planning officer has decided to adopt a formula which doesn't meet the full cost. I just want to know which doesn't meet the full cost, and it doesn't meet the full cost because it's predicated in part on a development that's no longer going to take place.
Well, I don't accept the factual premise of that second point, my lord, because that's part of the council's plan, its emerging plan, that it voted on, that those councillors said was sound.
So it is entirely, we've just 1213 is entirely based on the fact that penny feathers was allocated in the emerging plan. That's why it was done. From the evidence, as opposed to the argument subsequently.
And insofar as it being an emerging allocation, that's...
And is there any document contemporaneous that says that's what she did and why she did it?
No, but they didn't need to be, my lord, because it's not part of the officer chooses what to put in the committee report.
No, her witness statement. That's why I said any evidence.
No.
I'm not talking about the report. I really am not. There's no point in going off and answering questions that's not been asked. I'm trying my absolute best to understand why she did it. You're telling me she did it because of the emergent plan. And I'm just looking for something in the evidence, as I said, including her witness evidence, which says that that's what she did. And do I find it anywhere?
It's not in the witness statement, my lord, no.
Is it anywhere else?
What, the fact that it was that she
The
took
fact
that into
her
account.
mental exercise
Yeah.
included, oh, it's all right, it's in the emergent plan, we'll get something back from them eventually, or words to that effect.
You don't have that, my
We
lord,
don't.
no.
So there's no explanation to link it to the emergent plan then.
Well, save that that was the situation at the time. It remains the situation.
Yep.
That was known to that committee because they're the people
No, no.
that voted on it.
I'm wanting nothing to do with the committee, it's the mental exercises that the planning officer who did the contribution.
Well, it's certainly known to her. She's a planning officer of that authority in the planning department that submitted that plan.
Right, Dr. Bowes, I see the time.
Yeah.
Yes.
I wanted, before we rise, I want to check with you how we are doing on the timetable.
Yeah.
Because, in fact, on the agreed timetable, you began about an hour earlier.
Yes,
Have you finished round one?
I have, my lord.
Right,
Yes.
okay. Which is what you were allocated to achieve in half an hour today. In fact, we got to where we expected to be at the end. The only trouble is that you've had an hour longer than you were allocated.
Yes.
I'm not complaining about that, but what I want to make sure is that everyone has a fair opportunity to make their submissions tomorrow, and there's sufficient time for Mr. Streeton to reply.
Yeah.
When do you think realistically you will finish tomorrow?
Well, my lord, I said that I would be done by 12:30.
Yeah, that was on the basis that you'd start at 3:45 today.
Yeah. Well, I certainly will be done by then, but if you would like me to complete earlier than that, I should be able to do that by noon.
Yeah, I think you should aim to finish by noon,
Certainly.
which I hope will. Well, and I hope you don't need a full hour.
I don't anticipate I'll need more than the half that I've asked for.
All right. Well, because there's always a risk that, especially because of judicial questions, we may take longer than people expect. I am going to ask you, Dr. Bowes, to finish by 12,
So,
and the hearing must finish by 1, in any event.
certainly, my lord.
Okay. We will adjourn now until 10:30 tomorrow.
Great.